I'm Jeff Harrison. I'm here on behalf of Mr. Boyce. He's next to me at the table.
Thank you. You may have a seat. We are here for a preliminary examination on a one count of possession of methamphetamine and one count of a resist and obstruct police officer. Is there any resolution in this matter?
There is not a resolution. The people had sent a stipulation request to the defense to adjourn today because the necessary witness for the identity is a deputy who is in training today. Will not agree to that, but people are going to ask for adjournment for good cause.
Is this deputy from Grand Traverse County?
Correct.
Mr. Harrison?
That's essentially accurate. And I apologize to Madam Prosecutor. I was not available on Friday, and Monday being a holiday, I simply didn't have time to discuss it with Mr. Du Bois. I didn't even know it existed until this morning. So
Have you talked to Mr. Du Bois about it?
yeah,
Right.
he and I have discussed it.
And there is not a stipulation, am I correct?
There is not.
All right. Well, the court finds good cause to adjourn today's preliminary examination due to the unavailability of what would be a necessary witness. So we will reset this for next Tuesday. Anything else?
Not from the people.
Your Honor, under the circumstances, if I could be heard on bond briefly.
Any objection, Ms. Carey?
He's currently set at 50,000. I think part of the reason was there was some assumption at one point that there were several outstanding warrants. That is not the case. This is the only matter for which he has to answer at this point in time. Although he's on parole out of Grand Traverse, out of a Grand Traverse case, he's being supervised here in Webster County. I believe it's Mr. Van Admiral. All of the same considerations, I just want to play into the fact that he simply can't afford the bond as it's set right now, as far as that goes.
Anything else? Ms. Carey?
Thank you. I don't have his full criminal history in front of me. However, I believe that he does have a record in this county and out of this county. In this particular case, he was the passenger in the vehicle when the deputies turned on their lights and sirens. The driver of the vehicle they were in the driveway, tried to leave the driveway, and a pit maneuver was used to stop it, and Mr. Du Bois fled out of the vehicle and ran. He was then caught when he was being transported to the Grand Traverse County Jail. It's alleged, and he was in the hospital then for some time because it appeared that in the back seat of the patrol vehicle, he ate a baggie of methamphetamine. So he was in the hospital in Grand Traverse for a few days after that. I do believe he's a flight risk. I do believe he's a threat to society, and I believe the bond is appropriately set. I would ask the court to leave it where it is.
Thank you. All right, looking at the bond conditions contained in MCR 6.106. I said conditions, I meant factors. We looked at the prior criminal record. In 05, there's a home invasion second and an attempted receiving concealing of firearms. 07, an assault and battery. 11, a domestic violence. 12, a high BAC and attempted resist and obstruct. And 13, an operating while impaired, or I'm sorry, intoxicated. And 13, a driving while license suspended. In 15, an operating without security and driving while license suspended. In 16, a domestic violence second. 17, a domestic violence third. 17, retail fraud third. 17, larceny 200 to 1,000. 17, a resist and obstruct and driving while license suspended. In 20, a flee fourth, resist and obstruct, driving while license suspended. In 20, a joyride. 22, a domestic violence third. 23, an attempted resist and obstruct. In 24, an attempted tampering with an electronic monitoring device. The defendant is on I believe it's parole is what I have. Let me just double check that. Yes, he's on parole status. The probable cause affidavit indicated that he was in absconder status and had a warrant for that. Now, the probable cause affidavit does indicate that there were several other warrants for what I don't know, and those did not show in my lien. So those necessarily weren't taken into account by me. The record of appearance or fail to appear, flight to avoid prosecution. Well, we know there's a flee forth, a few resist and obstructs, completed and attempted. And then we also have an attempted interfering with an electronic monitoring device. History of substance use. I don't necessarily see any convictions for that. Seriousness of the offense charged, and the probability of conviction. That sounds like there is a probability of at least some conviction. And the seriousness of the offense charged, the defendant is charged with a 10-year felony of possession of methamphetamine, but as a habitual fourth, so that becomes a life offense. And the resist and obstruct as a 2-year felony becomes a 15-year felony. Responsible members of the community. I'm not seeing anybody nor have heard of anybody. Ties to the community. I know Mr. Du Bois does have a long-standing relationship to this area. And then any other facts, risk of appearance, non-appearance, and danger to the public. Mr. Du Bois, while I understand, was not the driver of the vehicle. He nonetheless fled from the vehicle and fled on foot, and only stopped when he was told the dogs would be deployed, and that he, again, was an absconder from parole status. Bond was previously set at $50,000 with a no controlled substance provision and a no recreational marijuana. I believe bond is appropriately set and leave it where it's at. Anything further?
No, thank you.
All right, we will see everybody next week.
All right, let's talk about that. This preliminary examination in front of Judge Corey J. Wiggins didn't make it far before hitting the brakes, but it still packed in plenty of substance, no pun intended. The key witness was unavailable due to training, so the prosecution requested an adjournment. The defense didn't stipulate, but Judge Wiggins found good cause and reset the exam for the following week. Real debate centered on bond, and it's here that the hearing got interesting. The defendant, Mr. Du Bois, sat quietly while his attorney, Jeff Harrison, argued that the $50,000 bond was too steep. Harrison emphasized that, contrary to earlier assumptions, his client had no other active warrants beyond this case, and while he was on parole, he was being supervised locally. His tone was professional, but a bit defensive, making the point that Du Bois simply couldn't afford the bond as set. Prosecute, he countered with a firm pushback, painting a far less sympathetic picture. She detailed how deputies attempted to stop the vehicle Du Bois was riding in, how he fled on foot until threatened with dogs, and how he later allegedly ingested a bag of fentanyl in the back of a patrol car, ending up hospitalized for days. Her delivery was crisp, matter-of-fact, and it left little doubt why the state viewed him as both a flight risk and a danger. Judge Wiggins then walked through the bond factors, and this was where his style really stood out. Calm, deliberate, and thorough, he ticked off Du Bois' criminal record like reading from a long grocery list: home invasion, firearm offenses, multiple domestic violence convictions, retail fraud, larceny, repeated resist and obstructs, attempts to tamper with monitoring devices, and even a fleeing case. The effect was almost overwhelming, and you could sense the weight of history catching up with the defendant. Wiggins noted that while Du Bois wasn't the driver, he still fled, had absconded from parole, and faced charges enhanced to life and 15 years as a habitual fourth offender. His conclusion was clear. The bond was appropriate right where it was. Du Bois himself didn't say much, have been for the best. His attorney handled the arguments, while he maintained a subdued demeanor, no outbursts, no visible frustration. That likely worked in his favor, but with the record stacked the way it was, quiet respectfulness couldn't outweigh the risk factors. The overall courtroom atmosphere was professional and steady. The defense tried to chip away at the severity of the bond, the prosecution responded with detailed facts, and the judge anchored the discussion with a careful review of the record. No chaos, no raised voices, just the serious business of weighing public safety against a defendant's liberty. In the end, the preliminary exam was bumped a week, the bond stayed locked at $50,000, and Mr. Du Bois left the hearing with the same steep uphill climb he walked in with. Judge Wiggins' handling was fair and thorough, reminding everyone that while courts can be patient, they don't ignore long records or risky behavior. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.